Welcome to Legally Agile with Chris Werner.
Welcome to Legally Agile, the podcast for founders and executives of high-growth companies who want legal strategy that keeps up with the business. Chris Werner is the founder of Vidar Law, helping high-growth businesses navigate risk, seize opportunity, and stay legally agile without slowing momentum. I'm Leanne Lyon, and today we're talking about AI and specifically the legal risks growth stage companies may be underestimating as they build, integrate, or rely on AI tools. It's great to see you, Chris.
Thanks, Leanne.
So, Chris, companies use AI in very different ways. From a legal standpoint, how do you distinguish between low-risk integration and higher exposure use cases?
Sure. So I think one of the main things we look at is what kind of company data is being given to the AI. I think when a company starts putting their own data in there, that's when the risk starts getting higher. AI is a lot of these tools are very, very powerful. And a lot of people who say they use AI are basically using like ChatGPT as a glorified search engine. If that's all you're doing, I'm not terribly concerned about that, right? I mean, maybe it's a better version of a search engine for you, but you're not putting in things that are risky. When you start giving the AI tool your company data, you start getting more risk. And then when you start building with the AI tool, you also start to develop more risk for your business in terms of ownership of the output. So it really comes down to how you're using it. But if a good rule of thumb is, if you're putting company data in, if you are developing a product that then you are going to turn around and consider an asset for your business, that's when the risk is higher.
So where are you seeing the most common blind spots, whether that's data sourcing, model training, output ownership, or maybe regulatory assumptions?
Yeah, I mean, I think all of those are important considerations. I think on an initial level, a lot of companies don't understand data retention within their AI tools. I know there's been a lot of discussion in at least the circles I'm a part of which tools will train on your data, but it's not just training. So data training is something that is talked about quite a bit. Most free plans will train on all of your data. Most paid plans, you will at least have an option to opt out of data training, and a lot of people are aware of that. But what they're not necessarily thinking about as much is data retention. So let's say I have a platform where I tell it can't train on the data I put in, but it does retain that data for a certain period of time. Sometimes there's legitimate purposes to it. Like, for example, if the AI wants to continue a conversation or a project that you're working on, it may need to retain some of that data in order to continue to help you, and you may want that. But what you may not realize is that it sits somewhere indefinitely sometimes, and then there is also a question of access to that data. Could your AI vendor be subpoenaed and be forced to turn over that data?
Well, for companies that are building AI-enabled products, how does intellectual property risk show up differently compared to traditional software?
Yeah, so it's funny. I've had a lot of conversations around this and ownership of that AI output that's coming out. And I think what I'm seeing is a lot of startups, a lot of young companies who are realizing, hey, we can shortcut our coding and our development by using some of these tools to create products, right? And what those products may be good and work well. And if you're simply using them to do your work better or to produce an output for your customers, that may be fine. But if your thought is you are actually building a piece of software that is going to have value to your company, you may be wrong about that. You may be wrong about the ownership of the intellectual property that comes out of those AI tools. If the AI is creating it with minimum amount of human input, you may find that there is no intellectual property ownership for that output. Doesn't mean you can't use it, but it may not be valuable as a business asset. And if your goal is to sell your business or even to bring in investors, they're going to look at that intellectual property and figure out whether you actually own anything or not.
Wow, that's a big challenge.
It really is. I mean, it's tough because you really have to think about how that works, and unfortunately, there's not a clear answer to that. Um, Years ago, before AI was a big thing, there's a funny story about a photographer who was taking wildlife pictures, and the way that copyrights on photographs work is the copyright is automatically in the name of the person who took the photograph, right? Um, and in this case, the photographer was doing an experiment and he left the camera out for this group of monkeys to interact with. And one of them picked up the camera and took a selfie. And if you Google monkey selfie, this image will come up. And if you're as old as me, you'll probably recognize it. But it was a very famous image. And somebody took that image and used it for themselves. And the photographer sued and said, I have a copyright. And the court said, well, actually, you don't, because even though it was your camera and even though you sort of set up the scenario, the animal picked up the camera, pushed the button, and took the picture. And an animal can't own a copyright, and so it can't even be transferred to the photographer. So the photographer didn't own the copyright, and anyone was free to use that picture without paying royalty. It's odd to think of it that way, but when you're thinking about the AI tools, some of those same legal principles apply, right? Are you doing this, or are you just setting the stage and letting something else develop the product? And that's going to be key to determining whether or not you can own that intellectual property output.
Okay, I'm actually a little speechless right now, but we'll continue. And I'm definitely looking up that image right after the show. Uh, so many founders assume that if an AI tool is widely available, that the risk shifts to the platform provider. But where does that assumption break down?
So I think that assumption is probably exactly wrong. The bigger and more widely used that the AI platform is, the more sophisticated that platform's protections are going to be for that platform. Um, there is something to the idea that if everyone else is using a certain product, then it must be okay. And in a lot of the business world, that's sort of a common belief, right? Well, if all my competitors are using this product, it's probably okay for me to use. I think the risk right now is we're still very early in the AI adoption phase. So even with things like ChatGPT or Claude or things that seem more widely available, I still think it's very, very early in the life cycle to say this is standard and so this is safe. I think that over the next couple of years, we're likely to see a lot of new laws and regulations being developed around these that may change the usage or the terms. And I also think we're likely to see a number of different lawsuits testing different theories of liability, even on, and maybe especially on these widely used platforms. So I think if just assuming, especially right now where we are today, assuming that an AI tool is safe because it seems like a lot of other people are using it is not a safe assumption.
In fact, I've heard the discussion that, the debate really, is it safer to use tools or is it safer to build your own proprietary AI where you do pour everything you know into it? Do you have anything to share on that debate?
Well, taken in um, just the question in isolation,
Mhm.
um, safer in terms of being protected. Um, your data is probably safer if you are building sort of a one-off, fully controlled product on your own, but I don't think that is the end of the story. Um, there's two obvious things. The first is the cost. I mean, it's not really practical for everyone to train their own proprietary AI model, and it's probably a bad use of resources for almost every company in the world. Um, but number two, training is in and of itself quite dangerous. So I won't get too far into the weeds here, but the way the training of an AI model works is you start by putting giant amounts of data into this model. And you make a decision at some point where you stop with that data input. So that's how much your model knows. But then you have to spend time refining that model. So you have a lot of humans putting in queries, running them through the model, and truly training that model on how it should be responding in various situations. And that training is a place where we have already seen liability issues come up. And it comes up in a lot of contexts. Discrimination is one, safety of the model is another. But to me, developing your own is probably not a good solution for most people.
So, how are investor conversations evolving around AI governance, documentation, and risk controls during diligence?
You see a lot of the same things that you see in most due diligence. But I think part of it depends on what your company is doing. So, for example, if your company is selling a tech platform, if you're trying to develop a new AI tool or something else, what the due diligence is going to look at is how much of the intellectual property do you actually own. Um, they want to know um, what you can protect, what you own. And they also are looking at, again, typical things for investors, right? What's the moat around your company? If you, Leanne, develop an AI tool and an investor comes in and wants to invest in or purchase your company, they're going to want to find out if I can go separately and develop the same tool with a minimum amount of investment because you have no protection over your intellectual property that's sort of crucial to that tool that you've developed. The other thing they're going to be looking at is obviously what your agreements with that AI are, and going back to the beginning, have you protected your data that you put into those any tools you might be using?
Can you share an example where a company integrated AI quickly and then later realized that there were contractual or compliance implications they hadn't anticipated?
Yeah, so I'm going to make this as anonymous as possible. So I don't want to disclose anything that is obviously privileged or confidential, but I will say I have seen situations where, especially for startups and people who are coming in, they have had issues not realizing how much of their confidential data was actually exposed in the AI tool, number one. And number two, they have not understood um, which portions of their tool they actually owned and controlled. So They thought they were developing something very unique. And as it turns out, there were investors who looked at it and said, well, okay, I see what you're doing, and this is a clever idea, but I can just do this. I can quickly write a script to do the same thing in like a Claude code or something like that, where I can fine. I don't have to sell this product, but I can do a very similar thing out of this. And so they ended up spending a lot of time and money developing this thing, and it was very good. And the investors looked at it and said, it's not good enough for us to invest in, or at least to invest at the level that the company was asking for.
So, as regulations develop at the state, federal, and even international levels, how should growth stage companies think about compliance without overbuilding bureaucracy too early?
Yeah, so compliance is a tricky one right now in AI as well. So in the US, we don't have any comprehensive set of AI rules governing the use or development of AI. We have states that are doing things, California, Colorado, Texas. We have individual states doing things. There's others, but we don't have a comprehensive system. The EU has a more comprehensive system. Australia has developed some rules. So the bottom line is there's a wide range of rules that may or may not be applicable. My sort of quick suggestion to these companies is, number one, you want to at least be working with an attorney who understands sort of the framework of what you're looking at and understands what you're trying to do with your company. Then you want to sort of identify those key areas. So, and this is company specific, depending on what you're doing. Obviously, if you're a health tech company, there's more regulations, but you want to identify those key bits of regulation that are going to be the most important. And from the beginning, be building with that in mind. And so you don't want to overdo everything. And there's always a cost component, especially for startups and smaller companies. So you really want to make sure you're identifying those key bits of things. And then really, you're going to want to build to that sort of highest level of compliance. A lot of times, the highest level of compliance is following the EU regulatory scheme. So even if you're in the US, you may want to build initially to that higher level regulatory scheme. That will ensure that if you do end up expanding to Europe, or if US regulations catch up, which they will eventually, you're already set and you don't have to change up what you're doing, or worse, go back and completely rebuild your product.
Well, as we wrap up today's episode, and this is for a founder evaluating their AI exposure today, what internal review or conversation would you prioritize in the next quarter?
I think if you're trying to make a list of things that you should do, number one, if you don't have an attorney right now that you're working with that understands, the evolving AI environment, you should go out and prioritize finding somebody, and at least getting them a basic familiarity with what you're doing. Then I would look at gathering up all of your contracts with any AI vendors or any vendors that you're using to help you build your AI. And then the third thing is I would gather up and start to review all of your intellectual property agreements, both with your vendors and with your internal team, and make sure that the company is owning as much of that intellectual property as possible.
Well, that wraps up today's episode. Thank you for listening to Legally Agile with Chris Werner. If today's conversation sparked questions about your own company, whether it's legal foundations, disputes, or getting deal ready, you can find more resources at vidarlaw.com. You'll also find a simple 72-hour dispute response checklist you can share with your leadership team. If you found this helpful, please follow the show and share it with another founder or executive who'd benefit. We'll see you on the next episode. Thank you, Chris.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.